So it's my great pleasure to introduce today's speaker, Professor Michael Rustad from Suffolk University Law School, somebody I've known of for a really long time, many years. And I ran into him again at Boston College for a conference, and he gave approximately this talk, and it was just so engaging and dynamic. I said, our students need to hear this. So I was really pleased that you accepted our invitation. We're willing to come. Thank you very much.
I'm glad to be here. It's clean, green, and serene in Concord, and really enjoy being here. Last time I spoke was about 20 years ago when Tom Field was very active in doing the IP Center, and it's always been so impressive, kind of the Vatican City of intellectual property here. When I got interested in social media in the December of 2012, when a journalist called me from Reuters and asked me about Instagram's terms of service, which had been changed very dramatically. They've been changed so that the intellectual property rights of all the users were basically forfeited to Instagram. So they could use your photographs for advertising, they could use your profiles, and even if that intellectual property could even survive, those rights could survive the termination of your account. Actually, that's what outraged some journalists, but what I found when I looked at the Instagram terms of service was I found a few clauses which were very troubling. In the new terms of service, they instituted something called pre-dispute mandatory arbitration, which basically said that you would have to arbitrate and forfeit your Seventh Amendment jury rights and your right of discovery, your right of appeal, but you had 30 days to opt out. In other words, you could stop using Instagram in 30 days and not be subject to this agreement. So I wrote about these terms of service, started looking at these terms of service and wondered whether, was it Instagram a rogue outlier, or was there something very characteristic about what the services were doing? One of the things about social media is just the numbers. And since 2012, you can see the growth and the changes. And we're talking about now billions of users. And they're ubiquitous. When we talk about social media, is that they're part of everyday life. They're part of the election. They're now part of, there's actually yesterday's on Easter Sunday, there was actually someone who murdered someone and put it on Facebook. So it's become a part of, a lot of the issues are so transparently ubiquitous. So I began in 2014 looking at these social media terms of service and contracting practices, and I looked at first of all, gathering the data. I looked at the Wikipedia terms at that point, but I also looked at, we had a number of international students from China, from Europe, and so I tried to identify all the social media sites that were dominant during that particular time. It became actually a very drudgerous project, 110 variables, 329 sites. First thing I learned is that social media may have originated in the United States around 2005, but they've become a global phenomenon. That even in 2014, there were many of them outside in Asia, there were a number of them in China, Germany, India, Russia, and so on. So what I wanted to do is talk to you a little bit what we know and still don't know about social media. First thing we know is that social media masquerade in the clothing of contract law. The terms of use masquerade in the clothing of contract law. So in other words, they take the form. Most everyone in this room probably can't remember contracts. The kind of contracts, the zombie contracts that we have today, it's a term where corporations extend and replicate their power over consumers. This idea that you waive your American citizenship of your firstborn son by clicking agree has become ubiquitous. People don't think about it. People don't even particularly read these agreements. Here's an example. You agree, the manifestation of assent, which is a basic foundation that you learned in first year contract, right? In this particular case, YouTube's terms of service asserts that those who merely visit the site are subject to their terms. The other point is that they're structured as rolling contracts, that they actually have they reserve the right to modify the contract at any time for any purpose. So U.S. courts, by the way, are divided on the idea of the rolling contract. Should the dominant party, for example, have the unilateral right to modify their terms at will? But 2/3 of the social media contracting contracts had that kind of form. They also take the form of sneak grab. Here's an example of what I call sneak grab. By agreeing to the terms of service, the user also consents to additional agreements incorporated by reference. For example, the user must agree to the terms of the TOU, the terms of service, the privacy policy. And the question is that would a reasonable person know what that is? So the user does not, in some cases, does not even have to check the box expressing agreement because the box is already checked for you. Which is really a long ways to, if you studied weeks of offer and acceptance, you may remember that first few weeks or even into the first month. But social media contracts really don't take that form. The second form is that these are zombie type contracts. These are contracts that are never read. In fact, a group of NYU researchers found that out of 1,000 online agreements, only 1 or 2 people actually read. And they'll read them for such a short period of time, there's no way that they could have actually studied the clauses. So here's the biggest lie. I have read and agreed to the terms of use. Empirically, they have not. And it turns out there's an indentured servitude clause that you accepted without reading. My favorite is, of course, the old, I've agreed to be the tall boy for Bill Gates by clicking yes. The third thing that we know about social media contracts is we know that in contract law, they always say there's a duty to read. If you didn't read, you're subject to the terms. There may be a duty to read, but apparently there's no duty to make contracts readable. So the online agreements employ this fiction that they're really contracts, but they don't make any pretense. And I decided to look at the readability of these terms of service and looked at a number of tests. There's a number of standardized tests for looking at the text. So what I did is I plugged the text into the formula, and we looked at the Flesch reading ease formula, which basically says the standard score is around 60. So the higher the score, the better. And I also looked at grade level, and I also used an Air Force test and then a consensus test to determine the readability. So here's the basic test, a Fleisch-Kincaid. So a score of 30 to 49 is considered very difficult, and the higher the score, the greater the readability. So a score of 60 is considered readable. Understand what the reading level is in American society. This is the American average member of a social media site has a reading level of grade 9. So keep that in mind. So the readability, this is the terms of use as a whole. So the mean is actually close to high school, 11.63. The median, right, 50% above, 50% below is at 12. And the mode is around 12. So that's a terms of service in general. So it's not too far off, only 3 grade levels, right? So, but the right foreclosure clauses, like what do we mean by right foreclosure clauses? Mandatory arbitration. Why is it a rights foreclosure clause? Because the damages are capped at $1 to usually $50. The cost of filing is $200 to $250. So you can't make it up by doing, and then there's also an anti-class action waiver. So warranty disclaimers, pre-dispute mandatory arbitration clauses, and then liability limitations. And you can see that many of them are in the very difficult to use. So here's a standard, 60 to 69, the readable. Most of them are fairly difficult to very confusing. That's for the terms. That's for the terms. But then you look at the foreclosure clauses, and you can see there's a very different pattern, right? So in other words, for the Fleisch-Kincaid, for the terms of service as a whole, it's nearly high school. But then you go to the warranty disclaimers, they're written at a college level, and then the exclusion of liability are even beyond college. So one of the things that you look at this is that you look at the arbitration clauses, and again, they're written to be very difficult to impossible. And again, they're beyond college. They're written at a level to be beyond college. So the arbitration clauses are 4 to five grade levels above the terms of use. So when you look at these arbitration clauses, they're designed, they're not only, first of all, they're not read, but even if they were read, they would be unreadable. The other point about social contracts and social media contracts is they're very difficult in the architecture, the design. Very few of them even have an index. So easy to have a hyperlink to each of the indexes. No indexes. They're very complicated. They incorporate the privacy policy by reference. And basically, they're long. In other words, some of them are, the mean is over 4,000 words. And 31 of the providers have over 5,000 words. But the most forthcoming of all the terms of use, and this is actually a fairly short one, was a terms of use from Nevada. Any dispute resulting from the use of our services will be resolved through arbitrary proceedings recognized by the state of Nevada. This is actually the most honest and forthcoming, and probably that they deserve the prize. So Woody Allen had a movie called Annie Hall, which is very popular when I was young. And he talked about life being divided into the horrible and the miserable. And that's the way terms of service are too. So many of them have what are called class action waivers, which means that you not only cannot initiate a class action, but you can't join them. So you can do the math. If you have a cap that's at $1 to $100, which is what the range is, and the filing fee for arbitration is $200 to $250, we don't expect that there's going to be too many cases. So this is what I see, that these social media terms of contract are nothing more than foreclosure schemes. They are very aggressive foreclosure schemes. They eliminate, we're all familiar with, in licensing of software, that we eliminate warranties. But at least we have, for example, in sale of goods, we have something called the Magnuson-Moss Act, which is a federal consumer act for many consumer transactions, that you can entirely eliminate the warranty. So they eliminate the warranty, they limit the remedies to some very nominal amount, which I call capping. They prohibit class actions or even joining a class action. They require mandatory arbitration, often in distant forums. And 61% of them who include the arbitration clause also include the anti-class action. So that's why I call these click wrap or browse wrap agreements, basically they're aggressive foreclosure schemes. They're one-sided. Basically you have rights without remedies. So 94 of the 329 social media sites I looked at had mandatory arbitration, often in distant form. By the way, when you looked at the US ones alone, the 188 US ones, that's where the mandatory arbitration was very common. That the caps on damages, the shortened statutes of limitation, and also not even able to use the small claims court. Here's an example. Any dispute related in any way to your visit or access to the QCHUP.com website shall be submitted to binding arbitration in Newbury, England. Here's another one from Mouth Wide Shut, is the arbitration shall be conducted in Mumbai. And by the way, the arbitration clauses are often buried. They're towards the end of the agreement. So what I see is a cannibalization of intellectual property rights, tort rights, contract rights through this kind of scheme. And when you look at this, Snapchat, you may remember, was sued by the Federal Trade Commission because they made the representation that all the photos and the snaps would disappear, right? And that wasn't entirely true. So the FTC filed suit. And they agreed to have a 20-year policing of their scheme. I looked at Snapchat's terms of use, and it turned out they had a liability clause which said that the liability was limited to $1. And they also had a mandatory arbitration clause as well. So in other words, so $1 would be your total recovery, and $250 would be the filing fee. So in other words, there is no private rights under such a scheme. So the mandatory arbitration particularly, I looked very closely at just there are mandatory arbitration in Mumbai, there are mandatory arbitration in Canada, but I looked only at the ones that were mostly US and Canadian sites, were American Arbitration Association and JAMS. Those are the two largest providers in the United States, right? So I looked at them closely, and they had 59 of those. And the central finding was that they, by their own terms, the social media contracts, violated the Consumer Due Process Protocol for both of those services. So American Arbitration Association and JAMS has special protocol for consumer arbitration. And then I looked at the clauses to see whether they really fulfill these. Here's some of them. This is one that's really difficult to operationalize. They say that, that a person is entitled to fundamentally fair process. Fine. One of the things we found that the social media terms of services were not reciprocal. So in other words, they sent you to arbitration in a distant form where you had to pay the fees, not of the arbitrators, but the fees to file, right? But they reserved the rights in federal court to vindicate their own intellectual property rights, and they sought complete indemnity if they were sued by the user contract. That's what we mean by non-reciprocal rights. The second one is that the remedy, that to have a fundamentally fair social media contract, there has to be a remedy. And to have a remedy of like Snapchat of $1 recovery and $250 filing is basically a right without a remedy. Third one is that unobtrusively, the best measure of fairness is who exercises these rights. And somebody has to do the hard work. I looked through all the American arbitration filings that were conveniently not searchable. So I had to actually physically look at them for both JAMS and the American Arbitration Association. And one of the things is that how many arbitration filings do you think that you would find? And it turns out that there were 0. And since I've done an update, I think I found 4. So if you talk about 2.6 billion users and 4 disputes, that seems like it's a liability-free zone that's being created here. So there's other measures of fundamental fairness too. Did they give a link where the user could have any information? It was kind of like that Nevada one where they said it's going to be subject to arbitrary proceedings, but there's no link, there's no place where you can get additional information. That seems unfair. No explanation of what arbitration entails. Not even the idea that that you lose your right to appeal, right to discovery. Did the social media provider disclose any right of discovery? That you'd lose any right of discovery, or mention that, 14% of the providers. Did they disclose that your right of appeal was narrowed? Only 17%. So they don't provide much disclosure either. So in other words, there's no procedural justice, but there's no substantive justice either. So the reasonable cost is that social media sites, some of them would assume the cost of the arbitrator, right? But that doesn't take into account the ban on the class action. Some of them also have loser pay, which would have a chilling effect, that if the loser pays, the consumer would have to pay Instagram's legal fees. Reasonably convenient location, that was almost never the case. The arbitration was always held in the provider's point of view. So there's a lot of very questionable due process issues. And here's the drought of arbitration filings. So if you looked at the estimated numbers of users, Instagram, for example, now is up to 100 million, and 0 filings, 0 filings, 0 filings. So it sounds like it's an effective way as well. It's an effective means. So here's the 4 of where there's actually a filing. No, these aren't judgments or settlements, but filings with Skype, Match, My Life, and Feed. You can see just a handful. Now 4 over, since the history of billions of users seems rather questionable. Okay, so let's talk about them. These are US style. These are US style. Foreclosing your rights, sending you to arbitration, anti-class action waiver, shortened statute of limitations. This is a heaven. This is the tort reform heaven where you can have rights without remedies. But the problem is that these social media providers are targeting users in Europe, which have mandatory rights Under the Brussels regulation, for example, consumers have the right to litigate in their home court under Articles 15 to 17 of Brussels regulation. So a choice of law. By the way, Facebook actually is one of the most progressive terms of use. They constitute about 18% of the universe. But they still require their users to appear in California or federal court. But that would not be enforceable in any of the 28 countries of the European Union because of the Brussels regulation. The second piece of mandatory, Europe has mandatory consumer protection, whereas the United States has a pro-market kind of approach toward social media. So the second one is the Rome I regulation on choice of law. So the choice of law means that the provider in the US style will specify their jurisdiction's choice of law, or one that's very friendly to their interests. But in Europe, that is considered a non-waivable right. So you can never be required to enforce, you can never be required to be imposed to the provider's place of business. The third one, the Unfair Terms Directive, it would strike down things like the complete disclaimers of warranty. They would disclaim, they would actually strike down the arbitration. So my biggest point is that these companies are going to be in for a litigation explosion. They already are subject to regulatory actions in Germany, in Norway, and United Kingdom House of Commons. The report said that a lot of these terms of use are like engaging with Shakespeare, commenting on how difficult they are. So I think what I think is the big picture is that yes, social terms of use and social media originated in the United States, but it is now in a global kind of environment. And so I think they're going to have to localize to take into account the mandatory non-waivable consumer rules. Here's one of the first pieces of lawsuits, was that AOL was sued in France, and they struck down 19 clauses of the AOL standard contract. So in other words, the idea of total disclaimers of limitation was completely found unenforceable. And until they changed the terms of service, they were fined every single day. The other point is that we focused in on China, which is one of the largest social media spaces. We compared the 25 largest social media websites in China to the 25 largest in the United States. And it turns out that China actually has the largest social media audience. They have 5 of the 15 largest in the world, but it's one of the largest and most important social media spaces. They have 629 million active users, and basically 7 of the 16 largest are now headquartered in PRC. So every day, the number of Chinese citizens joining Renren, which is like a Facebook equivalent, would fill 230 Tiananmen squares. So the Chinese terms of service, we had a Chinese co-author who was wonderful. And she was able to find that in these terms of use, that they did not include things like liability limitations. They had no arbitration agreements. They had no anti-warranties. Instead, what they had is clauses that were prohibiting antisocial conduct. So in other words, these social media contracts are destined to collide because of Chinese. We have a First Amendment, a very strong First Amendment, but the Chinese social media sites prohibit antisocial conduct. So the U.S. ones are strictly prohibited. And so when you look at just in China, which is there's an explosion of social media, and you see that these are very profitable social media sites. They're not using any of these disclaimers. They're not using anti-class action waivers and such. So here's what I think is going to be a long-term trend. Microsoft, which has a software licensing agreement, a consumer software licensing agreement, in China was struck down by a case by the Beijing's highest people's court, and they upheld a lower court, invalidating many of the limitation of liability clauses in Microsoft's standard US-style agreement. So the court held that the clause number 28 of the software agreement violated Article 24 of the new law on consumer rights. So it's interesting, China has an antipathy toward these standard form contracts. And simply, they will not be enforced of their contract law. So their amended consumer law grants consumers protection at the provincial law level, and they can bring the lawsuit where the rights were violated. That's the same as in Europe. So what we have here is that we see two different worlds. We see in the United States, we have the U.S. Supreme Court validating anti-class action waivers, mandatory arbitration, a market-based approach. And in China, their amended consumer statute includes increased compensation standards and penalties for violation, and also expanded liability for false representations. So what I see in this world is that the United States is going to have to move to either doing a minimum mandatory approach, that the approach of the U.S. style of disclosing these anti-warranties, I think, is short for this world. So thank you very much. Yeah.
So we talked about this a little bit at the Boston College Conference. I'd be interested in if we can talk to the folks here about. This is all, the contracts are all sort of a straight up, here's what's supposed to happen, dispute resolution. But the fact that there are 0 to 4 arbitrations with so many, million, multi-million, billion, whatever visits, didn't mean that there weren't disputes. It meant that people weren't going there, and so they were finding alternative dispute resolution mechanisms. For example, when Facebook changed its terms of privacy, then a lot of Facebook users deactivated their accounts. People hacked in and had Mark Zuckerberg, took his stuff public and things like that. So that it seemed like there's like sort of alternative routes that people take of like naming and shaming behaviors by some of the social media sites rather than arbitration.
There is. I mean, Instagram had a huge blowback when they changed their terms in 2012. But the ultimate result was Instagram keeps growing. I mean, so they might have lost some current users, but they've more than doubled since the change. They didn't change their terms other than the IP term. In other words, what they did is they gave the users basically would cede them a non-exclusive license for the term, but the basic provisions of arbitration, mandatory class action, partly the reason might be that people aren't mobilizing because they're not reading them. But the idea that in Facebook is that there's really not a meaningful place to go for Facebook. So Facebook, something like 70% of all adults join Facebook. So by terminating your account, you lose contacts with your friends, your imaginary family. In my day, growing up, you talk about I have so many Facebook friends I haven't met. Well, we used to call them imaginary friends. So I'm just thinking that if there was a robust market, is that there was really an alternative to go, self-help would really be the way to go. But there has been more mobilization, and it's so easy to mobilize. We've learned that, for example, in the 2016 election, how powerful the media can be, and how one rumor can change. And actually, Instagram had to back down on the IP. What was strange, though, is that most of their really draconian clauses still remain. So I wonder how effective that is. But my hypothesis is actually people when they feel like we have subscription sites like Match.com, right? And they are subject to arbitration. So my sense is that they go to the lawyer's office. They find out that you're subject to mandatory arbitration. You're going to have to go to their headquarters, and they, in these cases, are never brought. But there is, but I would acknowledge that self-help can work, and opinion is important. For example, a website could actually lose their whole identity, their whole market, if it became widespread. For example, that there's surveillance when there should not be. So I think it is possible that this is a world where I think self-help could actually play a role. But I think that there are many legitimate disputes which are not being brought. Arbitration, I've looked at arbitration before. I had an uncle that was a federal judge. He told me, look at arbitration. He was an arbitrator. He said, look at consumer arbitration. And I looked at it in another area called the nursing home negligence cases. And at that point, places like Texas were instituting mandatory arbitration for nursing homes. I was never able to find a single nursing home neglect case that had been brought up for arbitration. I went to all the different centers. So that's where I had the idea that it might be a rights foreclosure scheme early on. And the social media sites, there actually are bona fide disputes. Well, it's not just the intellectual property rights, but there's privacy rights. Facebook was brought to its knees in Europe, where we have very strong privacy rights, right? So a single law student in Austria was able to change Facebook's policy through litigation. Whereas in the United States, we haven't seen the use of litigation, so it is only the alternative dispute resolution, the self-help, that I think that plays a role.
I was thinking about the duty to read the terms of service, and I've been seeing some of them kind of change recently. Like some make you scroll all the way down,
Yes.
some have you open a PDF. Is there a legal reason for that, or?
Well, one of the things is that there's no legal rules at all, and the question is that many of them where you have to scroll down. The Second Circuit had a very famous case called Speck versus Netscape, and the judge in the Second Circuit was Sonia Sotomayor. And Judge Sotomayor wrote an opinion: if you have to scroll all the way down to see the terms of use, we're not going to validate that. But surprisingly, you would think that gave a signal to the social media sites and other social media sites that they shouldn't do that. They shouldn't have they shouldn't have the agreements below the fold. But that does not happen. They are extremely obscure. I mean, when you have to go down 5,000 words to see that there's a mandatory arbitration clause, they're not doing very much to make things user-friendly. It would be so easy to have a notice in the first clause that said this agreement is subject to mandatory arbitration, and if you have, and mandatory arbitration is, and just, for example, not to have what mandatory arbitration is, even to define it or to have a link to it. It's not that they don't know how to do a readable one. The Chinese, by the way, when they're, my co-author was looking at the readability, she says they're written at the third grade level. And I don't know if any more Chinese read them than Americans read them. But it's easy to design a readable terms of service. They're designed not to be read, and I think they're designed to be unreadable, just by having it at so many grade levels above what an average social media user would have. And the attorneys that I talk to, when they see an arbitration clause, they say, well, the U.S. Supreme Court is giving us this, giving a strong signal. We're going to validate that. And I can't take a case where there's a cap on damages, which is 200 times less. I mean, there's no shame apparently in these provisions. Some say that they're just copying each other. For example, Facebook had purchased Instagram, and Facebook had just been subject to a class action privacy. So that's what was behind the changes in their terms of service to have mandatory arbitration and anti-class action waivers. And I think what I've seen recently is they're copying them, and the number of mandatory arbitration and anti-class action waivers has increased in recent years. When you look at them from 2005 to 2017, the increase is dramatic. We're seeing it everywhere. It's partly they've read the Supreme Court decision, the Concepcion case. I mean, the Italian Colors case was a case in which this is an antitrust case, a state antitrust case, and they proved that the damages would be far less than the cost of pursuing the arbitration. The U.S. Supreme Court said that's fine. So I think they've got a signal from the U.S. Supreme Court. Anything goes, right? It's a free market approach. My argument is that the anything goes is going to get social media companies into a lot of trouble. These are global. When they're only targeting the United States, they have minimal risk. They have the risk, of course, self-help by users who might want to leave the service, but they certainly didn't have any meaningful risk of arbitration or litigation. But when you talk about Europe, you not only have consumer organizations, but you have official government-funded consumer groups that we don't even have in the United States. So Facebook has been tied up for a long time in Europe, but not in the United States, and that's interesting, isn't it? And there are a number of other high-profile examples out there. of where the US companies are getting in trouble in Europe, but not in the United States. And now in China, so Microsoft had never had a problem with their standard clauses in the United States. Right? They'd always had these anti-class action. They didn't have anti-class action waivers. They had disclaimers were completely enforceable. But in China, they get the highest court strikes down their standard agreements. So what's the signal? Question, Elizabeth?
Yes, I was wondering about Snapchat when there was a big privacy issue where it was hacked. Obviously, they updated their privacy, their policies after that. But was there any legal repercussions? Did anybody even try to go after them?
Yes, the FTC went after them. The Federal Trade Commission, which is under their Section 5 powers, the Federal Trade Commission is the chief regulatory agency of cyberspace, frankly. So they were able to get a settlement so that they had to change their terms of service as to the privacy policy. So they agreed also to have 20 years of auditing and to eliminate the misrepresentations about privacy from their agreement. So there was an effective FTC. But under this administration, I'm going to make a wild hypothesis that I do not expect a proactive FTC on our privacy issues. Second point is that I looked at the terms of service after the FTC action, and they still had the $1 cap on damages. $1 cap on damages, $250 filing fee for arbitration. So even if you had a privacy claim, how would you vindicate it on an individual basis? Your only hope is that the FTC would be active. And I think that's a problem because in the United States, our whole legal system is based on our ability to vindicate our rights. And when you structure it so that it is a fundamentally unfair procedure, it's not only fundamentally unfair by objective terms such as capping, but fundamentally unfair by their own terms. In other words, they've agreed to have American Arbitration Association consumer rules, but their clause reveals that they violate multiple provisions of the consumer process. I also looked at, they're supposed to be putting all their clauses in the American Arbitration Association database so you could examine them. No social media provider has done so, which is very revealing. But again, who's going to police it? And who's going to bring lawsuits when these anti-class action waivers and arbitration, these are the twin towers of liability foreclosure. And so I would conclude that Instagram's draconian terms of service are pretty much what the standard is. When you look at terms of service from other countries, in Europe, for example, they don't even attempt to do things like arbitration because they know that under the Brussels regulation, under the unfair contract terms directive, under the Rome I regulation, that they would be struck down. They wouldn't pass the laugh test. And now to have China having progressive consumer law, in the United States having draconian law, they're now operating in a globalized world. And so their counsel are not being served well by trying to use US-style terms of service throughout the world. They're going to have to at minimum localize it. But I would go further. I think we need some minimum mandatory remedies for US citizens. US citizens. Maybe maybe like mandatory, like the Magnuson-Moss Act, which is, first of all, Magnuson-Moss standardized the language. They said you had to use in warranties, full or limited, and they said what that means. So at least you had a meaningful disclosure. But they went further. They said you can't entirely disclaim your warranty of merchantability. There's a couple of states, Maryland and Massachusetts, say you can't do that in sales of goods. Maybe we need to move in that direction. Is that if we're going to have arbitration, it has to be either a telephone arbitration, where the fees are borne by the provider, or better yet, maybe have a government arbitrators that are not chosen by the providers, because there's a huge repeat player bias, even if they were able to, even if it was affordable. I was a counsel for Northeastern University in the 1990s, And basically, we arbitrated all of our cases involving employee disputes. Well, I had a record of 150 to 0. You know, this is the best team ever. You know, because when you're going before an arbitrator, they know that if they enter an arbitration dispute against the provider, they're never going to get hired again. Right? Elizabeth Bartolet, who teaches at Harvard Law School, actually went against the provider, and she never had another case brought before her. So I'm wondering whether arbitration could ever be fair, even if it was affordable. Given that the providers chose it, there's a strong repeat player bias. And likely, even if the costs were not prohibitive, I question whether consumer arbitration is something that could even be a realistic mechanism. Now, saying that, I understand that our courts are overburdened, our courts are expensive too, but maybe we need some kind of alternative where there's more neutrality in the tribunal to have a fundamentally fair process.
Just curious, while this is all playing out, have they considered using anything like an insurance endorsement clause, like, you know, in New Hampshire, this is the law, on any of these terms of service agreements, where they say in China, here it is, but then they still have a big long agreement?
Well, one of the things is that there's a lot of variation in the agreements. Facebook, for example, will localize. So if you're in Ireland, Ireland applies. If you're in your in other words, they make at least some attempt to localize. But most of them basically just put their headquarters as where the arbitration, where the litigation will be held, and under the terms of the law in that area. And as I said, under the Rome I regulation for the 28 countries of the European Union, you cannot do that. They have mandatory, non-waivable rules that the consumer's home court law applies in disputes. So we have completely what we see is America's from Mars and Europe is from Venus, and now China being at odds too. And so it only becomes a problem when the social media becomes globalized, which it is now. So when you're talking about 2.8 billion users, even since the time that I've collected my data, things have actually, I think with your question, I think things have gotten worse in terms of the consumer rights. And what kind of disputes are lost, I guess? And the whole role, what should the role of the law be? I mean, the law that you learned in contract law, the fact that you browse a website, that you should be subject to their terms and have to arbitrate in Mumbai. It seems like it's the Supreme Court has said that those kinds of one-sided provisions are apparently acceptable. But I'm thinking that we're not going to get any legislative relief, I don't think, very soon, but I think that just from a litigation perspective, the social media sites had better localize their contracts. So that if they are operating in China, they had better have a terms of service or software licensing agreement which will pass muster.